Hello, everybody, and welcome to this edition of Macro Pro and Friends. I'm Diane Cohen, and I am joined by James Rossi and Elizabeth Ewert. So how are the two of you?
Doing well, doing well.
Yes, well, we're really excited for your presentation today. But, I just wanted to know real quickly, what are you guys' holiday plans? Let's start with Liz.
Well, mine are the less exciting plans. We're planning on staying here, having some good breakfast, and hoping not to get too cold, but hoping for snow. So we'll see.
Snow. Oh, wow. Okay, that is good. And James, what are you going to be doing? And I know it doesn't have anything to do with snow after hearing Lizzie's request.
Yeah, I sure hope not. We're going to Costa Rica, and last I heard, it doesn't get snow at this time of year, if at all.
Oh, that sounds very, very exciting. So I have a poll question that is actually on the control console. So if you look at the polls, everybody, it says, where will you be? Or are you going to be at home, or will you be on vacation? Maybe you can put that in the question box. If you're going to be traveling, let us know where, because we'd love to know where. So James and Liz always do an outstanding job. They're with the Rossi Law Group, and they are always a pleasure to have as guest speakers. I've got a little bit of housekeeping, and then we're going to turn this over to them. So today's webinar is worth 1 CEU. You should receive it within the hour. If you don't, it's probably a firewall, so give it a little bit of time. If for some reason you don't get your certificate, please let me know. I have 30 days that I can assist you. After that, I can't assist you, so please let me know sooner than later. If you're calling in, GoToWebinar cannot record your time and attendance. So make sure that you've logged on to this webinar. If you have any questions, please put them into the question box, and I will be monitoring those and asking questions when we have the opportunity. And then lastly, there are handouts for this, so you can download them now so that you have them to refer to later. All right, everybody, it is now going to be turned over to James and Lizzie, and have a great webinar, you two.
Well, thank you very much, Diane. So we're going to get this first slide. There's the two of us. Lizzie is the Senior VP at Rossi Law Group. She's not only an amazing attorney, but one of my favorite people. So I'm happy to have you joining with us, joining me today with this group of mostly adjusters. And we're going to be talking about using discovery in your case and essentially to win your case. So we'll start with the first slide, which is, I'm sure most, if not all of you, have seen our defenses reference sheets. If anybody needs them, we'll send you the laminated copies. Just put the request into the comments and we'll get that to you. And it's obviously very important because it helps identify potential defenses. You can convey red flags and relevant information to your attorneys. And it's just a nice tool overall for creating your denial letters so that you can make a really solid denial letter. But just put a note in there that you need a copy and we'll make sure that you get it. If you need more than one, just indicate that as well. So the first thing we're going to do is we're going to start with the duty to investigate. Now, most of you are adjusters in here, and so this is an extremely important topic because you need to protect yourself and your company from penalties and improper bad faith behavior when it comes to administering claims. And so one of the things that includes is conducting a reasonable and timely investigation whenever you get notice of a work injury or a claim that's being made. And that means looking at all of the evidence and determining whether any of the benefits are actually due. If they're not, then you maintain your denial, etc. But you have to constantly be looking for any evidence that would suggest that benefits are due. And you can't just rely on the burden of proof is on the applicant. You must actually do a proper investigation, evaluating all evidence, and then making a proper decision. And that goes, it continues. So even if you've made your decision, you've got to say you denied the case or admitted the case, and new information comes in which would determine that additional benefits are owed or benefits are not owed that you thought were owed. That investigation is ongoing and continuing. Where it comes up the most is when you get new information. Maybe you've got a denial where the denial is based on substantial medical evidence, which is typically a pretty weak denial. And then you get new information such as a QME or a medical report that is substantial medical evidence, well, now you've got to start paying benefits even if you already had made a decision to deny. And then lastly, you've got to fully and fairly gather the information, regardless of whether it excuses or requires payment. Now, a couple tips are, the first is to document your investigation thoroughly. Your claim notes are a Bible. When you document your claim notes properly, at some point, a auditor can look at from the state. They can look at your claim notes and they're going to go, did this person do a good job? And are they acting in good faith? And are they, did they do whatever needed to be done to properly administer the claim so that benefits are owed or determined to be owed? And so this is something that you will always need to do. Anything and everything should be documented so that you're covered. If it's not documented, as a supervisor, one of the large TPAs always says, if it's not in the file, it doesn't exist. So keep that in mind and make sure that you include anything of relevance in your claim notes so that it's documented. And the other thing is sometimes, all too infrequently, people will not cooperate with the investigation and they'll frustrate it. And so if there was information that you needed and you're not getting it, you'll want to document your file of that so that you can be sure to be able to show that you in fact acted in good faith, and the only reason why you don't have that information is because the claimant frustrated your investigation. So the key is document your file with anything and everything relevant. This is the DWC-1. You're all very familiar with it. I don't know if you're all familiar with how important this document is, though. We're gonna cover the presumption of compensability later today in this session. More toward the end, we're gonna go into depth on it. But this document, when it's received by the employer, starts your 90-day window for investigating a claim to issue a denial or an acceptance. The other thing it does is when the employer hands it to the applicant, that starts the statute of limitations. So it's got two important points that come from the DWC-1 that you've got to be having them in the back of your mind at all times. This next document was created by attorney Randy Pollock, and I love it. It's something that you could just print out. It's all the things that you can look at. It doesn't include everything. It's not exhaustive, but it's fantastic. And it includes, all the things to look at so that you can evaluate whether to accept or deny a case. And so if you look at the top history of the injury from the employee, you compare that with from the employer, from the medical records, from the witnesses, what was stated in the first report, what was stated to the doctor's first report. But all of these are things to consider so that you can know that you did a proper and thorough job of evaluating the claim to determine whether it needs to be accepted, denied, and what benefits to be paid. Now we're going to touch on penalties and sanctions. We're going to be talking about discovery and how to defend cases, but it's really important that you understand that you have a duty to do good faith investigation, and otherwise you can get hit for penalties, and Lizzie's going to take that over from here.
And this is ongoing. This is why we want to hammer it home that you don't just investigate in the beginning, right when you get notice of a claim. You continually investigate, because oftentimes I'll see claims where they're denied, maybe in large part because the employer was unresponsive to the adjuster. But then later, 6 months down the road, they finally wake up and say, hey, let's participate, and you get information that suggests the claim should be accepted. At that point, you want to look into accepting the claim to avoid exactly what I'm about to talk about, penalties and sanctions. So as we all know, for the most part, workers' comp carriers are immune from civil actions. However, there is a provision under the Labor Code 5813 and 5814 that allows an injured worker to petition for penalties and sanctions if the insurance company is essentially not doing what they're supposed to do. Because remember, this is a benefits delivery system. It's not supposed to be a situation where the injured worker feels like they're fighting for every single benefit that's due to them. So moving on to the next slide. Under 5814, if there's an unreasonable delay or refusal to pay compensation to the injured worker that's due, there's a penalty of up to 25%, maxing out at $10,000. Now that sounds like quite a lot, but as I just said, this is a benefits delivery system. This is put in place to essentially penalize insurance companies that are unreasonably delaying benefits, and also to encourage insurance companies to do what they're supposed to do. There are additional penalties as well. If an audit is performed and it's determined that a denial was made without any factual, legal, or medical basis, that can be a penalty of up to $5,000. There are also individual penalties depending on the type of benefit that was not investigated properly. For example, medical treatment only would be $250 if it involves only one class of benefits, which would be temporary disability, permanent disability, or vocational rehab. $500 if there's 2 or more classes of benefits involved that were not properly investigated, or death benefits that were not properly investigated. This is $1,000. So this can add up pretty quickly.
Yeah, and Lizzie, as I was saying earlier with the defense's reference sheet, when the adjuster is going to deny the claims, they can include as much information as possible so that the other side is on notice of the basis for the denial. And not only does it put the other side on notice, but it also is good for avoiding that penalty of $5,000 for denying a claim without stating a lawful, factual, medical, or legal basis. So we include in that reference sheet, we include the code sections where applicable. If it's case law, we put that in there. So it's a really nice tool so that you can make sure that you include all your defenses.
On the same goes for documenting the claim notes. When an audit is requested and performed, they're going to be looking at claim notes. They're not going to necessarily be able to find the adjuster who handled the claim because that person may no longer be at the insurance company. And I don't know about you, but I don't remember every single detail of every conversation I had on a case 10 years ago. But if it's in the claim notes or it's in my personal log of notes that I keep, that's something you can reference back to. Moving along to even more penalties. No, we're not done yet. There are additional penalties if you're not properly paying for medical treatment. If you don't either pay for the services that are invoiced to you within 45 days, or you don't contest the payment, either that it was billed at a higher rate that's not allowed by the fee schedule or the treatment was not necessary, then you have to pay a 15% penalty as well as interest that accrues. There's also under 4650, if you are not paying benefits timely, you are subject to a self-imposed penalty of 10%. Self-imposed meaning you pay it yourself before you're asked to pay it. If you do not pay that penalty right away, so let's say you have an accepted claim and for all you know, the applicant's not treating, you don't have any work status reports, you can't get a hold of the treating doctor, and then 6 months later, you're served with medical reports showing you should have been paying TD benefits for 6 months. What do? You issue the check for 6 months plus 10% on those. If there was no way you could have gotten the medical reports, then there's an argument against that penalty. But if you do not pay the 10% self-imposed penalty, you could be subject to the penalties up to 25%. So,
and oftentimes the AAs are asking for 25% anyways. Yes.
So if you pay it already, then there's no argument to be made that you should be paying that extra 15% on top of 10%. Now, if they still push for 25%, you do get credit for the self-imposed penalty that you did pay towards any 5814 penalties that are awarded by the WCAB later. Sanctions are also another form of penalty in a way that can be assessed by the appeals board if it's determined that you're acting in a bad faith manner that's solely designed to delay or is frivolous. One example that I like to give of this, which is recent, and you may have heard about it if you pay attention to what goes on in the work comp community, which I'm sure you all do. There is a law firm in Los Angeles this year that got sanctioned $20,000, I believe, times 2 so far, may continue, for continually filing petitions for reconsideration and removal of a WCJ's decision to set a matter for trial. When the WCAB looked at it, they decided that, hey, guess what? This is a pattern in practice. It doesn't matter the facts of the case, they file this every single time, and it's solely designed to delay trials. So sanctions were provided at that point. There's all kinds of misconduct that can result in sanctions, but that's just one example.
Yeah, fortunately, we don't see sanctions very often, or even the threat of them. But every now and then, I can't even think of a time where we ever got sanctioned in workers' comp. Can you?
No, not that I can think of. And I will
Civil,
say,
it's happened, but not in comp.
I've heard judges threatening it, and I personally have only filed a petition for costs and sanctions one time
Yeah,
ever
me too.
in
Yeah,
over 10 years. And it's, for me, it's got to be egregious behavior for me to even
yeah.
consider it, let alone do it. And it's just not something that's typically done, at least not from an attorney's perspective requesting it. But judges, sometimes they have bad days and they
They
throw
want to
out.
make a point.
So yeah, keep an eye out for those.
All right, so why don't you take us through some discovery tools now?
So these are the fun things that you can request and go through, and it's kind of like you're a detective, so to speak. A couple here are the social media and background checks. I'm sure you're familiar with what these are, but background checks are really important because they give you a criminal history, which gives you tools for questions to ask at a deposition, which we'll get into in a little bit here. It also comes up with all kinds of aliases. And as I'm sure you know, a lot of cases, at least that we see, are with individuals who use 4 names, 5 names, 6 names. And if you find these in the background report, you can run them in other searches, such as an EAMS search, to see if the individual maybe used a combination of their different names to file a workers' comp case in the past. You can also get a list of addresses that you can use for a medical canvas, which is one of my favorite tools, and I'll get into that more in detail in a little bit here. And traffic violations, again, just another tool to find out whether there were car accidents, which could have led to prior injuries, subsequent injuries, just all material that is helpful, whether it's a denied claim or an accepted claim. And social media is another one of my favorite ones. It's kind of unbelievable to me what people post on social media. I personally don't have social media other than LinkedIn, but I've taken it upon myself to look in Facebook and see what I can find. And there have been times where I've found individuals. One case, for example, was a long, drawn-out upper extremity injury. We couldn't figure out why this woman wasn't getting any better. She had multiple surgeries, continued to have massive complaints of pain. The doctors wouldn't MMI her, but didn't know what to do with her. And I looked on there, and under one of her aliases, hence the background check, I was able to find she had a Facebook Live marketplace store that she would put these 2.5 videos up of her demonstrating makeup, showing off clothing, basically lifting and repetitively using her upper extremities, something she said she couldn't do. So took that information, deposed the applicant, she lied about all of it. And then right shortly thereafter, I revealed it to applicant's attorney and we settled the case. So it's useful, and sometimes it's people post things on social media about, say, James's upcoming vacation to Costa Rica, where you might say, oh, he's leaving Christmas Day. Let's send out an investigator that day to see if he's carrying baggage, stuff like that. So those are a couple of useful discovery tools.
And sometimes you can find the social media accounts of their family members too. So even if they don't have social media, their family members will be posting it. And so we've actually had multiple cases where using the family members' social media led to excellent evidence to refute a claim.
Definitely. Another tool that you can use, and I'm sure a lot of you are familiar with these as well, are AOE CEU investigations. What this is you assign an investigator to go out and interview employer witnesses. Sometimes they're cooperative, sometimes less than cooperative, but this is invaluable to a certain extent, especially in the beginning of a claim, because you can get a lot of information that you wouldn't have maybe at all, but definitely not until you have a deposition of the applicant. You can get perspective from coworkers who maybe knew the individual on a social level as well and knew, hey, this person may not have told the boss about this, but I know that this person goes out and rides dirt bikes and mountain bikes and injures themselves off duty all the time, or is really into golf. And I know that this person goes golfing at least once a month. And so these are tools that you can find out more information than maybe the injured worker would offer or a supervisor might have. It's also a way to streamline your investigation to know whether or not it was reported. If it was reported, who was it reported to? Did anybody see the applicant get injured? Even if the injury wasn't reported to a supervisor, was a coworker aware of pain complaints? Things like that that can help you make a decision whether or not to deny a claim or look into avenues where you might want to investigate apportionment.
Yeah, and the thing is, AOC investigations are kind of expensive, so you want to pick the right cases for them. But they can be extremely fruitful because you can learn about defenses you wouldn't have otherwise known. You can find witnesses you wouldn't have otherwise known that can help. Medical conditions, prior injuries, personal issues. There's so many things that can come from one. The best investigation that I have seen was some years ago. There was an investigator. We had a guy who got injured in the field. He was a field worker and he was an irrigator, and he would go from one irrigation post to another, and he would ride an ATV, and that was part of his duty, was to use this ATV. And so he ended up getting into an accident on the ATV and had extremely serious injuries and had to be airlifted to the hospital. And so we got an AOE/COE investigation assigned right away, same day, and the investigator got down there and he took photographs of everything. And one of the things that he saw was some tracks into the area where the accident happened. And he was able to piece it all together and show that this guy was doing donuts and burnouts and driving like a maniac. And it was all the tracks were photographed and videotaped. And so we were able to show that this guy's duties were outside the scope of employment at the time of this accident. And we ended up settling the case, but I think we settled it for about 5% of the value of the case. And it was because this investigator did such a great job in terms of the investigation. So AOE/COE is such an important tool. All of these are really important tools. If you use them correctly, all these things that we're talking about can really lead you to a successful defense.
Well, and to your point about only doing the AOE/COE investigation when it makes sense, that case you just described, of course, the exposure there was much higher than maybe a minor slip and fall, or let's say the guy twisted his ankle getting off the ATV and nobody's questioning that it happened. In fact, people witnessed it. Is that something you would have an AOE/COE investigation?
I sure wouldn't. In fact, I typically wouldn't, even if it's a minor injury.
Right.
I typically wouldn't have a full AOE/COE investigation, even if I may deny it, because I want to save some costs. But at the same time, the AOE/COE investigation, anytime there's a question, it's something you should evaluate completing.
Of course. And so this, back to the medical canvas that I mentioned earlier, if you look at the background report and you see, oh, hey, this individual has only lived in Los Angeles, let's say that's where the injury occurred for a year. And before that, they lived in Victorville. And before that, they lived in Sacramento. And they've lived in 5 different cities all across the state over the last 5 years. You know then that perhaps it makes sense to do a medical canvas using each of those addresses. And what a medical canvas is, in case we have any new folks on here who don't know, is you have somebody, it's typically an investigator of some sort, that calls all the medical facilities in a certain mile range of the person's address. I think a lot of times we do 30 miles, especially if you're in LA, because 30 miles, it could take you hours to go 30 miles in LA, depending on where you are. And what happens then is you find out not only what facilities have records, but some facilities will even give you dates of service and say, actually, there was a date of service 2 days before the alleged date of injury. And then you can look at subpoenaing these records. Once you get those records, you may be able to identify witnesses who could be helpful. For example, hospitals, if somebody went to the ER, if it was a serious injury, sometimes it'll list in the intake information who brought them in. And if it was maybe on the day of your accident and you have a buddy of somebody who brought them to the hospital, that would be somebody who may have witnessed the injury. And that could be somebody you want to question further. The medical canvas can also identify just additional facilities. And I know that, James, you had one case in the past where we weren't aware that the individual lived up in
Yeah.
Northern
Yeah,
California.
I'll tell him. I'll tell him about that case.
Okay, go ahead. There's your segue.
Oh, all right. That's a good segue. Yeah. So I had a case years ago where the TPA had paid out $200,000 on the case. It was 2 years old. It was an admitted injury, and they were just seeing a lot of malingering. And because of that, they referred it to counsel to do some. They wanted a deposition, some things like that. And so, when I got the file, I noticed that the accident happened in Sacramento, and he was a Southern California employee who was just up there for about a month doing the job. And so when I saw that, I said, why don't you get a medical canvas up north where he was? And so ultimately that medical canvas got a hit, and it was for the day before the alleged injury. And at that point, we then said, okay, well, let's subpoena the records of that facility. But first we took a deposition. And we took the deposition and asked him all kinds of questions about prior injuries, other injuries, car accidents, any kind of mechanism of trauma. And when we do this, we don't even need to have the records. We know what to ask. And so we'll ask all the different ways that they'll be asked. And we're going to show you an example later. But so that was done, and he denied it all. And so we ended up getting these records. And what we learned was he was in a motor vehicle accident the day before he made the work comp claim. So once we had those records with all of these denials, we then reversed our acceptance and went to trial on AOE COE. And at trial, all of the impeachment evidence came out, which to me it was pretty overwhelming. And the judge ended up, obviously we had to deal with the presumption of compensability too, but one of the exceptions is fraud. And so we alleged fraud, and ultimately we ended up getting a take nothing on the case, and then there was a criminal case thereafter. But the point being is, yeah, someone's in Southern California and that's where they do all their treatment. But if you have information which suggests you should go to another area and do a medical canvas, you should do it. Now, I'm not saying you go and do the whole state, because it actually gets really expensive. Medical canvases are actually pretty cheap as long as you stay within a certain location. But once you expand it, counties, states, country, it could be just enormous, very, very expensive. So you got to pick and choose where you're going to go. And in this particular case, picking and choosing, Sacramento ended up being a huge hit for us, and it led to, I can't remember, and I doubt they got all the $200,000 back from restitution, because in my experience, whenever I've gotten convictions and restitution orders, these applicants have most of the time spent the money. Other than one time that I can think of, I received a check in the mail for $50-something thousand, and I was just shocked by it because it's usually spent. But more importantly, you cut off all the liability, and we never had to pay out any more on that claim. So medical canvases, I love them. I'm a big fan of medical canvases, and they also you can get pharmacy records too. And we used pharmacy records to find all kinds of facilities that people treated at. Sometimes they didn't even come up in a medical canvas. So pharmacy records, I used to think, I don't really need them. They don't do too much. And I've changed my tune some years ago, and now I love them because they've helped on a number of cases.
I 100% agree with the pharmacy records.
Yeah. I know you've had success with them too.
Yeah. And then maybe not everybody's favorite, but definitely one of my favorite things is surveillance. As we know, surveillance video is admissible in workers' comp cases. And what ends up happening, there's two different types. There's manned and there's remote. I'm a fan of both. Remote is good because you don't have to have an individual there filming every time. The one downside of remote is there's a ton of footage to go through to see what's relevant or not. But surveillance is very helpful to figure out whether somebody is acting fraudulently or exaggerating, or to verify that their complaints are legitimate. Sometimes
they actually use AI to weed down the footage. They can do it so much quicker than you would imagine.
Yeah, no, I understand. I have one case right now. The reason that stuck in my brain is the applicant's attorney was objecting to us providing the clips of the relevant footage from the remote unless we serve them with all of the raw footage, which was going to take quite.
Here you go, take it.
You know what? That's what I said. I said, you want to sift through 72 hours worth of footage yourself, go right ahead, because you're
Have
not
fun.
for it, and I'm not going to bill my client for it either. So, you know,
Yep.
it is, but it can be really helpful because I have a few cases right now where gait derangement is coming into play. And you have somebody who, one case in particular, the individual goes to one doctor and is limping using a cane, goes to another doctor and there's no documentation of any issues with his gait. Now, what do you do in this situation? I'm suggesting surveillance, multiple days, and not just one, not just 3 days, because as you may or may not know, when somebody's limping, it may not happen every day. It may be an all day, every day sort of thing, but once you get the footage and you can evaluate, well, this person doesn't seem to be limping very often, or doesn't seem to limp at all, you can then depose the individual and ask them the questions. Do you ever walk with a limp? Well, yes. Is it all day, every day, the second you take a step? Yes. Well, now we have footage that shows that you're not being credible or you're outright lying. And that can be helpful to defend against either temporary disability liability, because we have an individual who says they can't walk more than 10 feet. And so they have work restrictions that are sedentary and we can't accommodate, or the employer can't accommodate. So we've been paying TD benefits for over a year. If you can dispute that with surveillance footage, the doctor might release them to less restrictive work restrictions or full duties. You never know. It's also helpful to prove fraud.
I'm a huge surveillance fan. I mean, not in every case, obviously, because it's expensive, but anytime you're suspecting malingering, or maybe they're working somewhere, you get a tip from an employer, or as Lizzie said, tips from the medicals. That's when it's appropriate. But keep in mind the cost. If it's a very small case, it may not be worth the investment, because it isn't cheap. And then, in my opinion, you always need, if you get good video, you always need a deposition as well, because you need to lock the applicant in so that they can't change their story. Because if you show the video to them before you've locked them into a story in a deposition, all they'll do is they'll tailor their story to whatever's in the video, and you haven't impeached their credibility. Unless, for example, I had a case where I get a call from an adjuster. It was a paraplegic case, confined to a wheelchair. And so we sent out some surveillance on him, and we get the video and we find, I get a call from the adjuster and he says, "You're not going to believe this. We got a paraplegic not being a paraplegic." And so apparently this guy was walking around and he had a little cooler in his hand and he's doing his thing. And I'm just going, "You got to be kidding me." It was a monster case. And I was just flabbergasted. And so I asked him, I said, "Well, has the employer confirmed it's him?" Because I didn't know what he looked like yet. I hadn't taken his depo. I had no idea. And so he says, "Well, I've already got the employer on it to confirm the identity and I'm waiting." So the employer ends up saying, "Yeah, we watched the video and the subject that you guys are talking about is not the applicant. But if you look at 1:20, that subject walks right past a guy in a wheelchair. That's the applicant." So our video did not do anything, and it was quite disappointing. Other than, at least this guy wasn't a liar and he ended up being a very truthful guy. But identity is a really important issue when it comes to surveillance, and so in that particular instance, it didn't work. But let's say it would have been him and he was walking around. There's nothing he could say that would have helped him get out of that case, because this was a guy confined to a wheelchair who was a paraplegic. So, but that's the rare instance. Any other type of case, the surveillance, without being locked in deposition, they can wiggle around it if it's anything subjective at all. So keep that in mind when you're doing surveillance.
And last but not least, our subpoena.
Well, second to last. My favorite's next.
And I really like subpoenaed records, and I'm not just saying that because Diane hosted us today, but they are very, very good evidence. And similar to claim notes that don't get documented, if you don't have records to prove prior injuries or prior complaints, it's almost like they didn't happen. So you want to subpoena records when you have these medical canvas hits, or you have your background report and it says there's some kind of a criminal case pending for, let's say, domestic violence. And they were maybe the recipient, unfortunately, of the domestic violence. You want to subpoena those records and see what's actually in the records, because sometimes things sound a whole lot worse before you actually have the records related to them. So identifying the targets to subpoena records from is your first step. One thing that I always do with every single new referral I get is run an informal search on EAMS. It takes all of, I don't know, 1 minute to put all the iterations of a first name. Maybe there's 2 first names, 2 last names. You have 4 different combinations to put together with the date of birth. And then immediately you have anything, at least with the names you've been given and the date of birth you've been given, to show whether there was a workers' comp claim. And then you verify with an EDEX. And an ISO report is invaluable. As far as I'm aware, all the clients I work with use those on every single case.
It's critical.
Yeah,
Critical.
because then you're getting workers' comp claims, you're getting homeowners insurance claims, you're getting motor vehicle accident claims, general liability claims.
Everything.
Everything is noted on there. If an insurance claim was made, it's going to show up. You'll also be looking at treating physicians. Look at what's on the medical reports. If you get subpoenaed records in, check and see what's in the subpoenaed records, because a lot of times it'll make reference to who the primary care physician is. If it's an ER or urgent care visit, it will say, you know, there's a section on there. It might even have a medical history questionnaire that the applicant filled out either at the doctor's office or when they filed their workers' comp claim. And other employer records are another example. This might show up in the background report. It may be something that once you've gone through a deposition, you find leads and you find out that, you know, there may have been some overlapping employment somewhere. You might want to subpoena those records, or a subsequent employer, and you want to see, well, hey, what did he say to his new employer about his physical capabilities when he applied for the job? And criminal records already hit that. So essentially, as we all know, once you're out in the world and you get treatment or you post something on social media, there's a trail. And our job is just to find it and then get those records so that you have the evidence you need.
And now is my favorite. Of course, you need all these other tools that we've just discussed for the depositions to really have any value. But my favorite is the deposition, because if it's done correctly, it's a lie detector test. And I use depositions as lie detector tests in a vast majority of cases. You know, anytime I have any kind of potential impeachment evidence, I want to maximize it by getting the applicant's testimony under oath and setting it up as a lie detector test so that I can test the applicant's credibility. Now, if they have credibility and they're honest and all that, then, you know, it doesn't turn into much. The claim's legitimate, the applicant's legitimate, and you just pursue, you know, closure of the claim the way you normally would. However, if they're not credible, then suddenly it brings in fraud, it brings in AOE, CEU, and if there's any kind of an issue that is, you know, he said, she said, well, they're not going to believe the applicant if there's a bunch of credibility issues based on impeachment. So I love the deposition, and I always tell my attorneys to make sure that you set it up. And so one of the things that I'll do is I'll say, if it's a car accident, say we do our ISO and it turns out there's a car accident or 2 or whatever it is, say maybe there's a couple work comp claims. We typically will not subpoena those records because like the EAMS, we can get a file from EAMS. We can get the WCAB files. That doesn't require notice to the other side. But if you subpoena like a car accident claim, things like that, they're going to get a copy of it as well. So what happens is, back in many years ago, when we used to just subpoena these records right away, what would happen is the good AAs, they would meet with their clients and they'd go over the records with them. And so then these applicants would just testify consistently with the records, and it would make my deposition to where I can't use it as a lie detector test. But if they don't know that information, they don't have that information, then I can set it up in a way that I can figure out whether they have credibility or not. And that's what it's all about. The credible applicants should get paid. The ones that are not credible should not get paid. And so that's how we use depositions, and it's just such a great tool. And I always say, if you have excellent impeachment evidence, potential impeachment evidence, lock it with a deposition so they have no wiggle room. And we're actually going to show you some sample depositions, just little clips of depositions on how we do it. We've got a mock deposition based on real cases, which is coming up very shortly. But this is a list of the type of topics that we normally cover. You'll see the medical history. That's typically going to be, that could be impeaching if you have priors and they don't admit it. But sometimes it's just you need to know what is the medical history, because you don't even know what it is and you don't have any impeachment, and you need to be able to do your investigation, subpoena records so that you can find out, if they had medical insurance, things like that. But we prove our elements of our defense. We need to know what our elements are so that we can ask the proper questions, figure out what benefits are owed, and then eliminate add-on body parts is a good one. And that's done by, for example, say you've got someone who makes a low back claim, and then for 5 months later, all of a sudden it's a neck and it's upper extremities, so on and so forth. And then that's when the application's filed and you got an attorney. Well, you can go through in the deposition and get all their complaints and their problems, and they may not even discuss half of the ones that were filed by the applicant attorney in the application. So that's one way you can get rid of body parts. And then evaluation of impeachment evidence, we're going to show you some examples. And then general background information is important so that you can find leads on how to get information that can help your defense. So this is a sample depo excerpt. And when you read this, I don't know who took this testimony. This is just random testimony. I don't know the case. I don't know what it is. But I can tell you this. By looking at it, I have no idea how the questions were asked, whether whether they asked the questions like, did the two of you ever work together? The attorney could have looked like a fool asking it. None of it matters, because this is what we see. We just see words on paper. And so the reason I'm including this is so that you realize it's not a show in a deposition. And I always make sure my attorneys know, I don't care what you look like. What I care about is what you get in that transcript, because that's what we're going to use. So if you need to pause and you need to take time to gather your thoughts and so on and so forth, it doesn't matter. All that matters is what is in that transcript. So what we're going to do is we're going to give you 3 videos that we're going to set up, and we're going to explain to you what it is that we do. These are Zoom mock depositions, real court reporter. There's an actor in there, and actually anyone who can name that actor will get a special gift. Just put it in the comments, and or in the wherever Diane tells you to put it. You guys see it. Put it in there if you know the actor coming up, and something special, and your address, and something special will come in the mail if you get it right. But he is just an actor. He's not a real applicant. He's not a liar. He's actually a wonderful, wonderful guy, one of my best friends. So Lizzie, I'm going to turn it over to you so that you can explain to them case example number 1.
All right, so for this one, we've got a 35-year-old who has a right shoulder that has already had surgery on the right shoulder, but he's alleging the shoulder injury was a result of a slip and fall accident at work. And the key word here is unwitnessed. Nobody saw it happen. However, it was accepted. Then when we run the ISO, we look and see, oh, hey, there's a hit here before the date of injury in our claim, and it's a motor vehicle accident, and under body parts injured, it says right shoulder. So what do we do in this scenario? Do we call applicant's attorney up right away and say, hey, this guy has a prior injury, let's settle? Of course not. We want to find out some information, and first of all, find out if this injured worker is going to lie about it or not. So we set the deposition to test credibility, and to, on the off chance or maybe likely chance he does admit to this prior injury, we want to find out the details of it. So here's an example.
And you'll see it's how it's set up to where we're going to ask questions in a checklist format. And what we're caring about is car accidents. We don't care about any other things because we know about a car accident. We don't have the records yet. We'll get them. But this is a sample of the testimony. And sir, have you ever had any sporting injuries?
No.
Have you ever had a slip and fall injury?
No.
Have you ever been injured in a bicycle accident?
No.
Have you ever been injured in a motorcycle accident?
No.
Have you ever been injured in a car accident?
No.
Have you ever been injured in any kind of motor vehicle accident as a driver, passenger, or pedestrian?
No.
And so you'll see in that there's a checklist, like James said, of questions to kind of put the deponent, I don't know if at ease is the right way of saying it, but make them think that we're asking a series of questions that we ask every single person. And I will say some of those we do ask every single person, but not only are we asking about car accidents, but we're reframing the question again right after that. And if you didn't catch it, it's have you ever been involved in a motor vehicle accident as a passenger, driver, or a pedestrian? That's another way of asking if you've been in a car accident without saying car accident, because the more times somebody denies being involved in whatever the prior injury or incident might be, the more powerful it is, because it's harder to wiggle out of and say, oh, I didn't understand the question. Well, we asked you 4 different ways and you said no every single time. So that's why we do it that way.
Yeah, and to add to that, you'll notice that I asked about bicycle accidents, sporting injuries, before I even touched on car accidents. And the reason I'm doing that is I want it to seem like it's a checklist so that the applicant thinks, I don't know anything. You know, I'll ask about skateboard accidents. I'll ask about all kinds of things before I get to the area that I really care about, because that's, if you think about lie detector tests that you've seen on TV, that's how they work. You got to ask the questions to set up their emotions so that you can determine whether they're lying. Well, here I'm setting up the questions in a way so that they have no idea I know anything at all. And so by the time it gets to the car accident, they think it's just a checklist question. Sir. All right, case example number 2.
So in this one, we have another 35-year-old, but this is a January 1st, 2024 injury to the right knee. When we do our informal EAM search, we find that there's 2 prior claims for a bunch of different body parts, and the knee is also listed. So we set the deposition again to test credibility about various things, but in particular, these prior injuries involving the right knee. Prior to your January 1st, 2024 date of injury, had you ever had any injuries involving your left knee?
No.
Prior to your January 1st, 2024 date of injury, had you ever had any pain in your left knee?
No.
Prior to your January 1st, 2024 date of injury, had you ever complained to a doctor or medical provider of any pain or problems involving your left knee?
No.
So the first time in your entire life you ever had any symptoms in your left knee was after your injury on January 1st, 2024?
Yes.
So obviously we got the side of the body part in the slide. Doesn't match my questions there, but regardless, the reason we're asking all of these different ways to find out whether or not he's going to admit to prior issues with the knee are, you know, I might be walking down the hall and all of a sudden I get a little bit of pain in my left knee because I do have a bad left knee, but that's beside the point. If you ask me in a few weeks or a few months, have you ever injured your left knee? I may say no, if all it was pain when I was walking down the hallway. But if you ask, have you ever had pain or problems in your left knee before a certain day, then I'd say, oh yeah, actually I did. And it was when I was walking down the hallway. And so again, the more times you ask it, the more ways you ask it are ways to lock in testimony and show that somebody is going to lie every which way. It also negates some of the argument that some individuals we depose have a very low education level. It might be somebody who didn't have any formal education. And there's an argument to be made that they didn't understand the question.
Interpreting issues.
Yeah, we're interpreting issues. So the more ways you can ask it, the better.
All right, so this is the third one. So now what we're going to do is we're going to show you a little clip of surveillance video. This is based on a real case where the applicant actually went to jail. The 34-year-old painter injured the right shoulder, and in our case, it was actually quite a few injuries, multiple surgeries, but the surveillance and the deposition testimony ended up just destroying the case and showed everything that he had from those surgeries. All the benefits were essentially unjust because of all the malingering that he did. But anyway, so we had so for purposes of this one, right shoulder claim was admitted, had surgery, TTD ever since, an abnormal MRI of the shoulder with constant complaints. So we know that there, since it's an abnormal MRI, we know there was something there. But social media search showed that the applicant had a lake house and owned a boat. So we assigned surveillance due to potential malingering. And this is a sample video. This is our actor again, though this is not real surveillance, but this is what it would look like. And so if we had video like this, and I'm looking at it for, I'll be analyzing that right arm, everything it's doing. It's going above his head. He's using some strength. There's some strength there. That does not look like someone who, can't use their arm. Now he's banging. Now he's pushing hard there. So this is all arm well above his head there. Now he's doing a thumbs up. And of course, the actor puts his sunglasses on and sits down. So if I have that video, I got to come up with a plan on how I'm going to bring that out without him realizing I know. Because if we served that video ahead of time, we would not get anything like the testimony that you're about to see in this example. It would be completely tailored to that video so that he's not impeached as much as possible. So you're claiming a right shoulder injury that occurred on June 1st, 2023. Is that true?
Yes.
And you had right shoulder surgery the following day on June 2nd, 2023, true?
True.
Since that injury, what can't you do now that you could before the injury?
I could lift my hand over my shoulder and I could just do daily activities.
So if you were in class and you wanted the teacher to call on you, since your injury, has there been a time where you could raise your hand above your head so that the teacher could call on you?
No.
Is that because of your injury?
Yes.
Has there been a time at any point since the injury where you could raise your right hand above your head?
No.
What if you took medications? Do the medications allow you to use the right hand above your head?
No.
What about when you had the injections to the shoulder? Were you able to temporarily move your right hand above your head?
No.
So since the injury, is it fair to say you have been unable to put your right hand over your head even one time?
I have not been able to.
And that's because of the injury?
Yes.
And is that the reason you're not working?
Yes.
And you're a painter, which requires you to raise your hand above your head to reach spots that are above you, true?
True.
Has there been any point since the injury where you feel you could do that?
No.
All right, so as you can see, this was not done really smooth. All the questions didn't come out all perfect. There's pauses. It's not a show. But if you were to go look at the transcript, everything that is said would be smooth because it's just writing on paper. And so we don't worry about what we look like. So in this particular incident, let's say he wasn't a painter. I would start it, what problems, what can't you do now that you could before the injury? That's a good way to segue into surveillance. But raising your hand in class, you create things that are similar to what the video shows, but in a completely different context so that they don't understand that you know something. And so that's how we do these things. And then we lock them down that they'd never been able to do it since the injury, not one time. And in this particular instance, there would be a number of additional questions about the sling. Do you wear the sling all the time? Have you been able to take it off? You know, things like that. And so by getting this kind of testimony with that kind of video, this guy got convicted. And so that's how we use surveillance. That's the most important way. I don't ever want to disclose anything. I had a case where the guy had his hand cut off, completely cut off and reattached. I think it was the first one that it was done in workers' comp. And he said he had zero use to the AME. And then in deposition, he told me zero use, like zero. And all we had to impeach him was him holding a key ring and his keys on a key ring and holding some papers. But that was enough to create a huge issue in the claim. And we ended up settling the case really favorably because of it. But the applicant, that surgery actually was a lot more successful than the applicant was portraying it to be. I'm not saying it was a cheap case to settle because the guy did have his hand cut off, but it changed the value of the case very significantly. So these are some of the other targets to depose. I'm not going to go into detail. We're getting close on time, but we can do person most knowledgeable. If we don't know, had a case where I was trying to get a drug test and nothing was coming back, so I said a person most knowledgeable to find out if the hospital did a drug test. OSHA workers, police officers, any kind of emergency medical personnel, things like that, they can all be helpful depending on your case. All right, next we're going to talk about the presumption of compensability. We're going to kind of fly through this. The first thing I want to tell y'all is essentially the presumption of compensability starts when the DWC-1 claim form is provided, which is the form on the left. And so it essentially, once the employer has that, or if you're the TPA and you receive it, even if the employer has it, the 90-day period starts. And it only starts when that happens, unless there is estoppel because the employer, for example, refused or said something that led the applicant to not turn it in, and it was, egregious conduct. Then they're going to be stopped from saying it. But otherwise, if it's denied within the 90 days of the DWC-1 being turned into the employer, it's timely. Your denial letter, just so you know, I'm going to run through these real fast. Your denial letter does not need to be in writing. However, remember what we talked about with the penalties earlier. You want to have your denial letter, all the different reasons for the denial, and you want it to be good. You can't have a denial that's conditional, meaning if you don't do A, your claim is denied. That doesn't work either. There's some exceptions. Whether an applicant is an employee is not covered by the presumption of compensability. The 6-month rule isn't. Good faith personnel actions are not. Statute of limitations is not. And I don't have it listed here, but I believe insurance coverage is not, for obvious reasons. This is the case, Honeywell. This is the case where it determined that the claim form is what triggers the 90-day period, the claim form being turned into the employer. Otherwise, there's estoppel, and that's, for example, they misled the applicant into believing no claim form was necessary, but there has to be reliance on it. There has to have been some sort of benefits lost. So we're going to do 3 quick questions, which all of you can do in your head, and this is going to show you when your 90-day period starts. Lizzie, you want to take these?
Sure. So for this first one, we have an applicant injured July 28th, 2015. He reports the injury to his supervisor the same day. Defendant gets the claim, denies the claim on November 13th, 2015. So this denial is well beyond 90 days after the date of injury and when the supervisor was informed. 95 days after he first went for treatment and lost time, 77 days after the DWC-1 was submitted, and 71 days after the application was filed. Was this a timely denial? I know nobody's going to chime in here.
No,
yes.
no, they're doing it in their heads.
And here's why. because the DWC-1 was submitted and 77 days later, the denial was issued.
So even though he asked for treatment and he reported the injury, 95 and 108 days earlier, it still was timely because all that mattered was the DWC-1. And this is Ellman versus Capstone. These are three real cases that we're doing. These are not made up. This is case law. Next one.
We have an applicant injured August 31st, 2012. Defendants deny the claim January 4th, 2013. Well, I don't have to do the exact math to know that's more than 90 days after the date of injury. A denial was 114 days after first treatment. Seems kind of late. Denial was 101 days after the application.
So even an application was filed.
Yeah, man, it doesn't sound good. It's not looking good. But the denial was 78 days after the DWC-1 was provided to the applicant. Do we have a timely denial?
And actually, I think that should have said to the employer. That's a typo. That's on me. I typed that. So, and the answer is.
Survey says yes. Because again, 90-day time limit starts from when the DWC-1 is filed with the employer.
That DWC-1 is what matters, folks.
Yep. Our last one, we have the injury a while ago here, June 29th, 1992. Denied the claim October 19th, 1992. Denial was 112 days after the date of injury and 91 days after the claim form was filed. Was this denial timely? Yes, barely, but here's why. This is where you'd have to whip out your calendar and take a look, because the 90th day would actually have fallen on, and I didn't read out the word Monday on this one, which may have thrown you guys off, but the 90th day would have been Sunday, which is not a court day or business day, and so they would have had until Monday, the 91st day, which is the day they issued the denial to deny the claim.
Yep, and the thing is, I would have recommended issue your decision on the Friday before, because yeah, this case says this, but you never know when case law is going to change, and you don't want to be the subject of that change in the law. So I always avoid potential changes. And one of the ways I do so is by using the date of injury as the start date for your investigation period. And keep in mind, not all types of claims are 90-day windows. Some are shortened, and you can remember when COVID was reduced to 30 days, for example. But if you use the date of injury where you can never be late, because as long as it's within the 90-day period, it's timely. And then the DWC-1 doesn't even have any relevance in that respect. A few more tips for claim handling is obviously promptly investigate your claims for using reasonable diligence as they come in, so that you can determine what benefits are due. Make sure that you document your file very well, so that if you're audited, that you're clean. If you are using a post-termination injury defense, obtain documentation from the employer confirming the termination or layoff. And I'm saying that because what happens is sometimes a case is filed and it's denied by the adjuster because the applicant resigned. Well, a resignation is not a termination. And so years ago, I saw multiple times where the applicant attorney would then file a 132A discrimination case because we denied the case based on post-termination injury, but there was none. So now the employer has a 132A petition that they've got to defend at their own cost because it's not covered by insurance, and it was caused because the adjuster didn't make sure that there was a termination or layoff. And then keep in mind the file could be audited, so document it well. And that does it.
Yeah. Thanks, everyone.
Yeah, thank you. Thank you so much for attending. And keep in mind that if you can name that actor, put it into the notes, and I'll send you that special gift. If you need the defense's reference sheet laminated, put your name and address in there and we'll get it for you.
Okay, so I want to make sure, because I've had lots of people ask for that, and I want to make sure they say, please send it to me, but they don't give us a physical address to mail it to. So please make sure you put your physical address in there. And we're going to have to just stall a little bit before we end to give everybody the opportunity to put that in. So I would just like to say a few things. First of all, thank you both very much. I always enjoy working with both of you. James and I are actually going to be doing the last CEU for this series on the 23rd. So we certainly hope that you guys will join us for that. We are going to be talking on unlocking the secrets of apportionment. And that should be very good. James is always great to work with. In addition to that, I don't know if all of you guys are aware of this, but MacroPro actually provides many of these services. You had talked about, getting more records and things. One of the things MacroPro can do is we have something called MP Discovery. We will go through the records and see if there are any additional records that you may not be aware of and send you a list of them and see if you would like a copy of those for your investigations. So that's a service that we provide. And of course, we also provide the internet and social media as well as a background check, and we do the medical canvassing as well. So these are things that you can get from us. It's all about gathering records. So if it's about that, you know that MacroPro is on it. All right, well, I would like to thank you once again, and we will see you guys soon at the next webinar. And the very next webinar is going to be, the 12 days of the DIR, and that is always a really good presentation. Chris Bowen from WCI are going to be doing it, WCR, and she's going to be doing it. And so we'll see you at that presentation. Bye, everybody.
Happy holidays.
Merry Christmas.
All right, bye-bye.